Hello and welcome to this webinar giving an update on the latest developments under TUPE. My name is Louise Merrill. I'm a Senior Solicitor at Clarkslegal within the employment team. This webinar is going to be approximately 30 to 35 minutes long, which includes some time for questions at the end. We'll be covering the core concepts of TUPE, and this will be just a very brief refresher to remind ourselves of what TUPE is and why it's important. A summary of some of the recent key TUPE cases, including those relevant to service provision changes, and our predictions on the impact of Brexit on TUPE. So firstly, just a refresher on the terminology we'll be using. The transferor is the outgoing employer, and the transferee is the incoming employer. TUPE stands for the Transfer of Undertakings Protection of Employment Regulations. TUPE was originally implemented into UK law in 1981, but it was significantly amended in 2006, and it underwent some further amendment in 2014. TUPE implements a European law directive, namely the Acquired Rights Directive. This means that English courts and tribunals are required to construe TUPE in a way that gives effect to the general purpose of the underlying directive, namely to safeguard employees' rights on the transfer of a business. The aim of TUPE is to protect employees when a business changes hands or when there's a change of service provider by moving employees and their related rights and liabilities to the new provider or employer. However, TUPE will only apply if there's a relevant transfer. A relevant transfer can occur in two situations, where there's a transfer of an undertaking or business in whole or in part, and there's a transfer of an economic entity which retains its identity. This is a business transfer. And the second is where a client engages a contractor to carry out work on its behalf, engages a different contractor to do that work, or brings the work back in-house, and that's known as a service provision change. So some transfers may be both a business transfer and a service provision change, and there are also certain circumstances where TUPE will not apply, and we'll touch on some of these in a bit more detail later on. There are, broadly speaking, four core concepts under TUPE. You should note that there are some exceptions to these principles, but we'll not be going into those and into that level of detail for the purposes of this webinar. So first, there's the automatic transfer principle. Where TUPE applies, the relevant transfer does not terminate the contracts of employees of the transferor who are assigned to the relevant business or service. Instead, the employee's contracts of employment and all their rights, powers, duties and liabilities in relation to these transfer to the transferee. The transferee effectively steps into the shoes of the transferor. Secondly, any dismissals of employees because of the transfer by either the transferor or the transferee will be automatically unfair. Thirdly, any changes to the transferring employee's terms and conditions of employment because of the transfer will be void. And finally, any employees affected by a TUPE transfer are entitled to receive through their appropriate representatives certain prescribed information about the transfer and its implications before the transfer takes place. And in certain circumstances, those representatives must also be consulted with regarding any proposed measures to be made in connection with the transfer. So let's look in a bit more detail at service provision changes, and then this will lead us on to some of the recent cases in this area. Unlike business transfers, which directly implement the meaning of relevant transfers under the Acquired Rights Directive, service provision changes were a new category of relevant transfer introduced in 2006. Now, the 1990s saw a spurge of companies outsourcing work in a focus on cost-saving measures, and case law was left to deal with whether these arrangements could be caught by TUPE, and this led to a lot of uncertainty. Therefore, service provision changes were expressly included in TUPE 2006, and thereby extended the scope of TUPE protection in the UK beyond the minimum EU law requirements. The interpretation and the scope of service provision changes has been a key focus of UK case law and has been the main area of recent development. As I mentioned earlier, service provision changes will cover a first-generation outsourcing, and this is where a client decides it would like to outsource a service to a contractor, or where the client appoints a contractor to provide a service which is not currently being provided. It will cover a second generation outsourcing, and that's where, having outsourced work, a client decides it wishes to transfer the service to a new contractor. And it will also cover insourcing, and this is where the client seeks to end a contract with a contractor and bring the service back in-house. In all of these situations, the client on whose behalf the activities are being carried out must remain the same. The activities which are transferred must be fundamentally the same before and after the transfer, and immediately before the transfer there must be an organised grouping of employees which has the principal purpose of carrying out the activities on behalf of the client. There are some express exemptions carved out in TUPE when a service provision change will not be a relevant transfer, and this is namely where the client intends that those activities will, following the transfer, be carried out by the transferee in connection with a single specific event or a task of short-term duration, and also where the activities consist wholly or mainly of the supply of goods for the client's own use. For there to be a service provision change under TUPE, activities do not need to remain identical following the transfer, but they must remain fundamentally the same. This is a question of fact and degree, and it's therefore not surprising that disputes over this point are very common. The tribunals are expected to adopt a straightforward and common sense approach. So this issue was considered in the Employment Appeal Tribunal case of QLog v. O'Brien in 2014. Just to note, in this webinar I'll refer to Employment Appeal Tribunal as the EAT. In September 2008, the client, Ribble, entered an agreement with the contractor, McCarthy Haulage, to transport and deliver Ribble's cardboard packaging products across the UK. The agreement defined the services to be provided by McCarthy as the delivery of all bulk loads of corrugated products manufactured by Ribble from its premises to destinations on the UK mainland. McCarthy employed drivers, a transport manager and 4 shunters to carry out the service on behalf of Ribble. In September 2011, Ribble terminated this agreement and entered a new contract with a logistics contractor, QLog. QLog did not employ drivers, and instead it subcontracted out the transport service to various hauliers. The agreement between Ribble and QLog stated that Ribble wished to transfer the provision of part of its transportation, delivery and distribution services from its incumbent provider to QLog. It further stated that QLog was agreeing to carry out transport and logistics services. Transport services meant the services relating to the physical carriage and distribution of goods from and to Ribble's sites, and logistics services meant arranging the hauliers for these transport services. QLog maintained the risk for goods right up until the point of delivery. Now, QLog accepted that the shunters and the manager would transfer to it under TUPE as they were associated with the warehousing aspect of the service, which QLog provided in essentially the same way as McCarthy did. However, it disputed that TUPE applied to the drivers, as it said QLog was not providing the service itself, it was subcontracting that part out. As is often the case where TUPE is disputed, the drivers found themselves in no man's land, and by that I mean that McCarthy continued to insist that TUPE applied and dismissed the drivers, and QLog continued to insist that it didn't apply and refused to employ the drivers. And in these situations, as is common, the employees are left with little choice but to bring claims against both companies. The EAT had to determine whether the activities undertaken by QLog were fundamentally the same as the activities previously undertaken by McCarthy on behalf of Ribble. It found that the activities were fundamentally the same, notwithstanding that they were being carried out in a very different way. The agreement between Ribble and QLog provided compelling evidence of Ribble's intention that QLog should continue the previous activities, namely the transportation of Ribble's goods from its premises to its customers. Whilst QLog had a very different mode of operating the service, the actual activities that it had agreed to carry out on behalf of Ribble were the same as those previously carried out by McCarthy. The EAT stressed that identification of activities was a question of degree and fact in every case. The decision demonstrates that TUPE may apply even where part of the service is subcontracted out, provided the incoming provider takes responsibility for the entirety of that service. The EAT did suggest that the outcome may have been different if, for example, the services were split so that a different contractor assumed responsibility for transport. Leading on from this point about splitting the service, it is common for employers to assert that activities are not fundamentally the same because services have been split between contractors and thus fragmented. And let's look at a recent case on this. In Arch Initiatives versus Greater Manchester West Mental Health NHS Foundation Trust, Bolton Council had contracted out drug and alcohol support services in the Bolton area. This was undertaken by the Trust's Alcohol and Drugs Directorate until the 31st of December 2012. The services were retendered and split into two separate functions, namely case management and the delivery of interventions. ARC Initiatives was awarded the case management function, and another company, Lifeline Project, was awarded the intervention function. Trust employees who've been carrying out the case management service argued that they should transfer to ARC Initiatives on the 1st of January 2013, but ARC Initiatives did not agree and refused to employ them. Again, the employees were left in a very uncertain position and brought claims against both ARC Initiatives and the Trust, and the tribunal had to determine whether there was a service provision change. The EAT found that there was a service provision change of the case management function from the Trust to ARC Initiatives. It said there was nothing in TUPE that expressly requires that the relevant activities should constitute all of the activities carried out by the outgoing provider. The issues are whether activities were fundamentally the same and whether there was an organised grouping that had as its principal purpose the carrying out of those activities. In this case, the service provided by the Trust comprised different activities, namely case management and interventions. The splitting of the service along the lines of its activities and transferring those activities to different contractors did not preclude a service provision change. On the facts here, there were two organised groupings, one consisting of the Trust employees who had been performing as their principal purpose the case management function, and the second organised grouping was just one individual who had been working on intervention. Thus, in this case, there was a service provision change in respect of the case management activities. Now, this case is not a shock, and it's in line with the existing understanding of the law, and it would have been a shock had the EAT concluded that TUPE did not apply, and it would have had quite an impact given that it's quite common for services to be divided along functional lines where there is a change in provider. The judgment again stressed here that there's a common sense approach that's needed when you're looking at service provision changes. A service provision change will not arise if the client's intention at the point of transfer is that the activities will be for a single specific event or a task of short-term duration. And there's recently been two EAT decisions clarifying the scope of this exception. In Horizon Securities Services Limited, v. Nadiz, Mr. Nadiz worked as a security guard employed by PCS Group at an office complex. The site was owned by Waltham Forest Council, and the management of the site was contracted out to a company called Workspace, who let out the offices to their clients. Workspace subcontracted out security services to PCS, who employed Mr. Nadiz. In January 2013, Workspace notified PCS that the offices would be closing and that they'd be demolished, and they were going to be replaced by a supermarket, and as such, the security contract was terminated. Waltham Forest Council tendered out for security services for an 8 to 9 month contract whilst the site was pending demolition, and Horizon successfully tendered for this contract. When the issue of TUPE arose in respect of Mr. Nadiz, Horizon challenged the application of TUPE and refused to employ Mr. Nadiz. Mr. Nadiz claimed unfair dismissal, and one of the issues the tribunal had to determine was whether the activities awarded to Horizon were a task of short-term duration, so as not to amount to a service provision change. The tribunal at first instance said that although there was an apparent intention for the business centre to be demolished, no definite date had been given for this, and thus Horizon have been engaged to provide a continuous service rather than a service connected to a single specific event or a task of short-term duration. However, the EAT rejected this reasoning. The EAT said that the focus is on the client's intention regarding the activities at the time of the transfer and whether it was intended to be a short-term task. This would be a question of evidence for the tribunal, and thus the point had to be remitted back to the tribunal to assess. However, we didn't get very far with this point in this case because the EAT found there was no service provision change because there had been a change of client and no need to consider this point about tasks of short-term duration any further. And I'll briefly touch on the change of client argument in a moment. The issue re short-term tasks was further considered by the EAT in ICTS UK Limited v Mardi. In ICTS had a security contract for a university campus which closed in 2012. ICTS continued to guard the vacant site, and in July 2013 the site was purchased by a Malaysian university for major redevelopment. The new site owner entered a new security contract with First Call Secure Group Limited to guard the vacant site pending its redevelopment. First Call refused to take on the employment of any of ICTS's security guards based at the site, including Mr. Mardi, on the basis that there was no service provision change as the task was short-term. The EAT found that whilst the intention of the client at the time of the transfer is key, events occurring after the transfer are relevant in ascertaining the client's true intention. In this case, several months after the contract commenced, no planning permission had been granted for any building project work, and no work had commenced. These were relevant factors in deciding if at the time of the transfer the client really did intend this to be a short-term contract. The EAT also found that a mere hope or wish from the client that the contract is short-term is not enough to avoid there being a service provision change. There must be a firm intention, and this case was also remitted back to the tribunal to be considered on the facts. But what we can draw from these cases is that when you're assessing whether activities are in connection with a single specific event or a task of short-term duration, it's the intention at the point of transfer that is relevant. That being said, the conduct of the parties following the transfer will be relevant in determining what the initial intention was. The Horizon case is also a good case to illustrate a further point on TUPE, namely the change in client argument. It is accepted law that the client on whose behalf the services are carried out must be the same pre- and post-transfer for there to be a service provision change. In Horizon, to avoid liability, PCS needed to show that the client on whose behalf the services had been carried out had remained the same. Post-transfer, the client was clearly Waltham Forest Council as it had engaged Horizon directly. Therefore, PCS needed to show that its client pre-transfer was also Waltham Forest Council. Horizon argued, however, that pre-transfer the client of PCS, for whom Mr. Nadiz worked, was Workspace and not Waltham Forest Council. The EAT found, as findings of fact, that PCS had been engaged by Workspace. Workspace had let out offices within the business centre and the tenants were their clients. PCS had no relationship with Waltham Forest Council. It determined that on these facts, PCS's client pre-transfer was Workspace, and thus there had been a change of client and TUPE didn't apply. The EAT said that it was not appropriate to conclude that the security services were being provided on behalf of Waltham Forest Council simply because it owned the building. There had to be more. However, in the slightly later case of Jinx v London Borough of Havering, the EAT stated that a tribunal should not assume that the client of a subcontractor will always only be the party that it has a contract with. Who the client is a question of fact, and it is perfectly possible for a subcontractor to have more than one client. Now let's take a look at two recent cases on whether a temporary cessation of activities prevents TUPE from applying. The two decisions are Inex Home Improvements Limited v Hodgkins and Mustafa v Trek Highways, and they considered whether a service provision change can occur when employees working on the contract are not active at the time of transfer, for example, where they've been temporarily laid off. In Inex, Thomas Vale Construction plc subcontracted painting and decorating work to Inex. The work was released in tranches known as work orders. Work order number 8 was completed in December 2012. Due to the lack of orders from Thomas Vale, Inex temporarily laid off a number of its employees. In January 2013, Thomas Vale gave works order 9 to a different company, Local Run Decorating. The work under this works order was substantially the same as the work carried out under the previous works order by Inex. The laid-off Inex employees argued that they had transferred to Local Run as this was a service provision change under TUPE. Local Run argued that they did not transfer as they were not active at the time of the works order. One of the conditions of there being a service provision change is that there is an organised grouping of employees which has as its principal purpose the activities that are carried out on behalf of the client. And Local Run argued that this was not satisfied at the point of transfer. The EAT found that there was a service provision change and employees did transfer, despite them being inactive at the point of transfer. It stated that common sense suggests that a temporary cessation of employment, including for the purpose of holidays, sickness, or a temporary layoff, should not deprive the employee of their employment if there is a service provision change during the period of temporary cessation. This broad interpretation was approved in the later EAT case of Mustafa v Trek Highway Services Limited, which found that a temporary cessation of highway maintenance work by Trek's employees at the time of transfer, which was the result of a dispute with the client, did not in itself prevent there being a service provision change, and whether there is an organised grouping of employees is a question of degree. The crucial point from these cases is that a temporary cessation of activities will not necessarily prevent TUPE from applying, and you need to ask if there's an organised grouping at the point of transfer, even though its activities may have temporarily ceased. There is another area of TUPE which applies to both types of relevant transfer and causes much case law, and this is namely the question of assignment. The automatic transfer principle in TUPE states that a relevant transfer shall not operate so as to terminate the contract of employment of any person employed by the transferor and assigned to the organised grouping of resources or employees that is subject to the relevant transfer. Regulation 4.3 of TUPE states that any reference to a person employed by the transferor and assigned to the organised grouping of resources or employees that's subject to a relevant transfer is a reference to a person so employed immediately before the transfer or who would have been so employed if they'd not been dismissed in circumstances described in Regulation 7.1, and that's namely the employees that have been unfairly dismissed because of the transfer. There's no statutory definition of assigned under TUPE. Whether an employee is assigned to a grouping of resources or employees which is transferring is a question of fact, and an obvious relevant factor includes the proportion of an employee's working time spent working for or within that specific group and on those activities. However, case law has repeatedly stressed that this is not the only factor to be considered. In the EAT decision of Costain Limited and Armitage, it was confirmed that whether an employee was assigned was a question of fact, and it can not be assumed that every employee working for a particular contract or client is assigned so as to transfer. It found that over-reliance was made on the percentage of time the employee spent working on a particular contract. So in this case, the employee was employed as essentially a project manager tasked with troubleshooting problems on contracts, and it just so happened that he spent a large proportion of his time working for one particular client who obviously had a lot of issues, and this was on this occasion up to 80% of his time. But that didn't mean he was assigned to that client's contract under TUPE. Assignment depends on all of the facts and circumstances and time spent is one of several factors to be considered. Other relevant factors that tribunals will look at when they're assessing the assignment includes where and what task the employee does and spends most or all of their time on. What does their contract say about what they do? And how are costs allocated with regard to their role? To transfer under TUPE, the employee must be assigned immediately before the transfer, so he or she must essentially be part of the transferring group at the point in time of the transfer. A recent case has considered assignment in the context of a suspended employee. In Jacowlu versus Nestor Prime Care Services, Ms. Jacowlu was a care manager with Nestor working on a contract with the London Borough of Enfield. Nestor's contract was due to end and a new contractor, Westminster Home Care Limited, was due to take over. Ms. Jacowlu was suspended by Nestor pending disciplinary proceedings, and Enfield instructed Nestor to remove her from the group of employees providing the service. However, Nestor objected to this instruction and took no steps to reassign Ms. Jacowlu away from the Enfield contract. Following the change in contractor, Westminster refused to accept the employment of Ms. Jacowlu on the basis that she was not assigned to the Enfield contract at the time of transfer because she was suspended and also because of their instructions to remove her. The EAT found that suspension was no different to holiday or study leave or sickness absence, so would not in itself prevent an employee being assigned to a grouping. With regard to Enfield's instruction to remove Ms. Jacowlu, the EAT considered that as Nestor did not follow the instruction and only Nestor had the power to remove her, she had remained assigned. However, had Nestor accepted and followed Enfield's instructions and effectively removed her before the transfer, she would not be assigned and so would not have transferred under TUPE. This case potentially encourages outgoing contractors to keep problematic employees on contracts they know that they are losing or will lose in the future, and ignoring a client's instructions to remove those employees from the contract so that they transfer to the new contractor. However, obviously such a move may be in breach of contract depending on the terms of the commercial contract with the client, and of course may upset your relationship with that client if you have an ongoing commercial relationship with them on other matters. So what about employees on long-term sick? In BT Managed Services Limited v. Edwards, the EAT had to consider whether an employee on long-term sickness absence at the time of transfer was assigned. In this case, Mr. Edwards had not worked since January 2008 due to a heart condition, but remained employed by Orange as he was entitled to permanent health insurance and had been receiving regular payments under this scheme since 2009. In 2009, his employment transferred to BT, and in 2010, a conscious decision was made to keep Mr. Edwards in employment so that he could continue to receive the payments. In 2012, the BT service was transferred to Ericsson. Ericsson argued that Mr. Edwards was not assigned to the service, and so he didn't transfer. The EAT found that to be assigned, something more than a mere administrative or historical connection to the grouping was required, and there must be some level of participation in the activities being transferred. Where an employee is temporarily absent from the activities, there is an expectation that they will return, and so they will remain assigned. However, where the absence is permanent and the employee will have no further involvement in the activities, then they will not be assigned. The EAT therefore found that Mr. Edwards, due to his permanent absence, was not assigned and did not transfer to Ericsson. It should be noted that in this case there was a strong emphasis on the employee being away from the activities permanently, and employers should not apply this reasoning to employees on long-term sick whose length of absence is unknown and who may well return. So, as we all know, on 23rd of June, the UK voted to leave the EU. Article 50 of the EU Treaty sets out the legal mechanism for a member state to exit the EU, which begins with notice being served under Article 50. And David Cameron stated in his announcement on the 24th of June that notice would be served by the next Prime Minister. So the process to leave the EU has not actually been triggered yet. Once it has, extensive negotiations are likely to take place on the arrangements for the UK's exit, which could take a couple of years, if not longer, to conclude. Until the UK leaves the EU, TUPE will apply as normal. However, the question is, what happens to TUPE after the UK has left the EU? The truth is that no one knows for sure at this stage. No country's ever exited the EU via Article 50, and thus we're in uncharted territory. However, we can make some predictions with regard to TUPE. It's highly unlikely that TUPE would be repealed. For starters, the UK legislation actually goes further than the EU directive ever did, required showing a willingness on the part of Parliament to extend protection here beyond that which the EU envisaged. Further, TUPE has become ingrained in UK law, and there doesn't seem to be any political appetite to remove it completely. However, TUPE is a complex area of law and one which is often perceived as overly burdensome on employers, and it's therefore likely that some of the provisions of TUPE will be relaxed, building on the changes that were made in 2014, and in particular, changes are likely to be made to make contract harmonisation easier following a TUPE transfer. However, the extent of the changes and what they are may well depend on the government that's in power at the time. So that leads us to the end of the webinar. Before we go, we've had some questions coming in during the webinar, and there's quite a few, and we've got a bit of time to take a look at a couple of these now. Megan, could you read a couple of these out?
Yeah, so we've got, how does the decision in QLog fit with earlier decisions such as Johnson Controls, where changing who carried out the service did result in the activities being seen as different?
Well, it's a good question. It's one that it's actually a good demonstration of how fact-sensitive TUPE is, because the Johnson Controls and QLog, they're very similar sounding circumstances, but they have given rise to different outcomes. So for anyone that doesn't know the Johnson case, it's a case involving a taxi administrator who worked for Johnson Controls, and the service that he provided included booking taxis for clients, but also other admin duties such as allocating jobs out, checking invoices, and I believe he would try to allocate jobs out in a way that was most efficient for the business and could pool jobs, for example, if it was more cost effective. One client decided to do away with this service and instead have its secretaries book taxis for it directly. So it had a group of secretaries and they would just book taxis ad hoc as and when required. There was an argument in the Johnson case about whether TUPE applied in respect of the taxi administrator, and in particular whether the activities that he carried out pre-transfer were the same activities, or fundamentally the same activities as would be carried out by the secretaries post-transfer. And in the Johnson case, it was held by the EAT that activities were not fundamentally the same once they transferred to the secretary. So I guess this is where it's similar to the QLog case, in the sense that those who would be carrying out the service pre and post transfer had changed. But in Johnson, the decision, as the person asking the question has pointed out, it was different. I actually think that QLog is in line with the Johnson decision, because the principles that came out of that case were that you need to use a holistic approach when you're assessing the activities. So so you can't just have a breakdown of the activities and then just tick them off as and when they transfer over. So in Johnson, the taxi administrator's service was a centralised service, so he could, as I said, pool jobs and book taxis more efficiently. And the service post-transfer wouldn't have that element to it. It wouldn't have that centralised element to it. It would just be the secretaries booking things independently. And so there was a change in the service being provided as well as the people carrying out the service. And this is why QLog actually follows Johnson, in that when you apply a holistic approach, the services that were being supplied pre and post transfer in QLog were fundamentally the same. They hadn't changed. It was just the people doing the work that had changed. So I guess, as always, cases just on TUPE are always fact sensitive, and different outcomes on similar facts just show how difficult it can be for tribunals to make those decisions and assess those activities.
Great, thank you. We've got another one here, which is, following cases like the Arch Initiatives case, does this mean that a company could break down a service into different groups of activities and could have numerous organised groupings, and is there a limit?
The short answer is yes, they could, and no, there isn't. So again, it will be a question of fact and degree in each case, and employers will need to consider what exactly are the activities which are said to be transferring, and whether these have remained fundamentally the same, and then you look at whether there's an organised grouping that's actually carrying out those activities that has that as their principal purpose. And I guess depending on how a company is structured, service may well be able to be broken down into lots of groups of activities, and you could have multiple organised groupings that are carrying out those activities. So yeah, there's no limit, and you could have quite a few. I think that's probably all we've got time for today. Apologies if we haven't had time to cover your questions. There are a few more on here. We will be posting updates on TUPE on our Employment Buddy blog, so make sure you take a look at those. And all that's left now really is just to thank you very much for listening in.